Hi there and welcome to Estate Planning 101. I'm going to give you a brief introduction to what estate planning is in this video. When I say estate planning, I'm talking about who should make financial and medical decisions for you if you become incapacitated, and then upon your passing, giving what you have to who you want in the way that you want. Now, if you haven't set up your own estate plan, then you're on the default plan, which is probate and conservatorship. I'm not going to get into the default plan in this video. I've done that in another video. I just want to focus on what your estate plan consists of in this one. So the main document in your estate plan, or the heart of your estate plan, is going to be your living trust. It helps to think of your living trust like a bucket. So your trust bucket is going to hold title to your assets. So you're going to put your assets in this trust bucket. So for example, your home will go in the name of this trust. Your non-retirement accounts will go into the name of that trust. For example, my trust is called the Wood Family Trust. So the title to my assets is the Wood Family Trust. So you're putting the assets in the trust bucket. There are three key players in the trust. There's the grantor. That is the one who sets up the trust. They put their assets into the trust. There is the trustee who manages the assets in the trust. And there's the beneficiary, the person who benefits from the assets in the trust. So the trustee manages the assets for the beneficiary. Now, when you set your trust up, you're all three: grantor, trustee, and beneficiary. It is business as usual. The way that you manage your assets now, before having a trust, will be the same way that you manage your assets after you have a trust. The only thing that changes is the title of your assets. It says trust. You will name a successor trustee, so whoever you trust to act as the manager of those assets in case you become incapacitated, and the person that will distribute your assets to your beneficiaries in the way that you specify. So the beneficiaries are the people that you want to receive your assets upon your passing. And you'll determine, for example, if they're minors, at what age should they get those assets. If they're a spendthrift, if they have special needs, how should they get those assets? So those are all decisions that you'll make in your estate plan. Now, along with the trust, there's other key documents in your estate plan. So, for example, there's the power of attorney, where you name somebody called an agent to manage assets outside of the trust. So, for example, your retirement accounts. So the agent will manage the retirement accounts. They will also generally manage your affairs. So they'll sign contracts, do your taxes, collect your mail, whatever it is that they need to do, the agent under the power of attorney will be able to do it. Usually the trustee and the agent are going to be the same person. There is also the Advance Healthcare Directive, where you will name somebody also referred to as an agent to make healthcare decisions for you. Now, the healthcare directive agent will make those medical decisions, and they'll also be named in a document called a HIPAA authorization. And the HIPAA authorization gives them access to medical records, and it gives them the authority to be able to talk to your doctors. So, and they'll need to do that, of course, to make medical decisions. So they'll have access to your medical records and have the authority to make medical decisions. So these are three of the main documents in your estate plan, the trust being the heart of your estate plan. They're not the only documents in your estate plan, but three of the most important ones. So the trust is a private document. This is important to remember. So it's not a public document. You don't have to register it anywhere. Unlike probate and conservatorship, which is totally public, a trust is totally private. So I'm Stephen Wood from Wood Law, Wills and Trust. Thank you so much for watching.